Walker. I am a program manager here at the Coordinating Center with the Community First program. I have over 30 years of experience working in the health and human services field. 19 of those years have been here at the Coordinating Center, again in the Community First program, where we support individuals in the home and community-based services. Prior to the Coordinating Center, I spent 15 years working for an adult medical day program. So again, we welcome you all here this afternoon.
Hey, thank you, Tangent, and hello, everyone. My name is Megan Bazette, and I work alongside of Tangent in our Community First programs or Supports Planning Division. I've been here at the Coordinating Center for just over 3 years, and similarly to Tangent, have been in the human services field for quite some time, just over 25 years now. Just a quick note that although she will not be facilitating with us today, Tangent and I would like to recognize licensed clinical social worker Nicole Dozier, who was instrumental in the development of this presentation. Nikki long served as the center's resident expert in this area, and we are really grateful for all of her contributions. Next slide, please. Okay, let's go over just a few ground rules before we get started. Today's presentation will be recorded. However, as Heidi mentioned, the Q&A portion will not be recorded. We ask that everyone just please remain on mute throughout and that you use the chat to submit questions that we will go ahead and address during the Q&A. Please remember that this is a safe space with no judgment. Participants agree not to share any personal information or opinions that are shared within the group outside of the discussion. If everyone could please silence their cell phones, and please know that slides, documents, and unanswered questions will be emailed out after the presentation. Next slide, please. Okay, and due to the legal nature of our topic today, we just want to emphasize that this webinar is intended just for informational purposes only and is not a substitute for any professional legal advice. Next slide. Okay, so our objectives for today include the following. Participants will be able to, first of all, describe various types of documents that are available pertaining to healthcare decisions, to differentiate between these types of documents, and also to understand when to seek clarification regarding the decision-making process. Next slide, please. Okay, and before I turn it back over to Tangent, I'd like to take a moment before we get into our first topic to just recognize how confusing the language can be surrounding this entire topic. There are many terms that might seem similar, but that have different meanings legally, and we're going to do our best to define each of these for you as they come up throughout this presentation today. Next slide.
Thank you, Megan. So let's go ahead and dive into our first topic, which is advanced directives. So many of us have likely been in a healthcare setting and been asked if we have an advanced directive in place. Although the term is commonly used, a thorough explanation is not always provided. Our goal today is to provide that explanation so that everyone leaves with an understanding of the types of advanced directives as well as their purpose. Next slide. An advance directive is really as simple as its name. It's a legal document providing individuals the opportunity to identify their choices and express their wishes in case a time comes when they're unable to do so. The two most commonly used forms of advance directives are the durable power of attorney for healthcare and the living will. So let's look first at the durable power of attorney for healthcare. A power of attorney is one of the terms listed on our confusing language sheet just a few slides back that Megan referenced. Also called a POA for short, a power of attorney in general is a legal document in which the individual identifies a trusted person or persons to act on their behalf in case there is a time when they're unable to do so. While there are several other forms of POAs, such as financial POAs, our goal today is on a POA specific to healthcare. The person or persons that an individual appoints to make healthcare decisions on their behalf is also known as a healthcare decision maker, a healthcare agent, or a healthcare proxy. Those terms can be used interchangeably. One or more people can be named in order or together. The other most commonly used advance directive is a living will. A living will is also a legal document and one in which an individual can state what emergency medical treatments and care they do and do not want in order to sustain life. This is different from a will, which provides direction about estate affairs, a celebration of life, cremation, burial arrangements, gifts, and care for any dependents. In a living will, the individual might make decisions based on their condition related to CPR, use of a ventilator, use of artificial nutrition and hydration, and use of pacemakers or implantable devices. Although not seen quite as frequently as the durable power of attorney for healthcare and the living will, advance directives do come in other forms. These include declarations for mental health treatment and choices surrounding organ and tissue donation. Next slide. So let's talk about advance directives in terms of when they become effective. Most advance directives will specify when the document becomes effective. Effectiveness may take place when two physicians have certified that the individual lacks capacity to make decisions. Alternately, individuals may choose to have their advance directives become effective as soon as they sign in conjunction with two witnesses. It is important to note, however, that effectiveness taking place as soon as signatures are obtained does not give the person identified in the power of attorney as the agent the right to override the individual. If an individual has the ability to dictate their own medical care, they have the right to do so. Immediate effectiveness simply takes away the need to involve two physicians to deem an individual incapable of making decisions in order to make the document effective. Next slide. A few additional notes about advance directives. Some people avoid completing advance directives because they don't want to think about their end-of-life wishes. Understandably so, this can be a difficult topic for some folks, and it impacts us all in different ways. It's important to remember that one document can be done without completing the other. Individuals don't have to do the living will portion, they can just do the healthcare agent portion. In Maryland, advance directives do not require a notary, but they do require two witnesses. It is the responsibility of the individual and their agent or agents to maintain the most current version of these documents and give them to medical providers. Advance directives do not expire, and only the individual can change an advance directive. Next slide. This next slide shows a couple of examples of different types of advance directives. The document on the left, the 5 Wishes booklet or the kit, is an advance directive format that is legally valid in many states, including Maryland. Benefits of this format include its use of easy to understand language and its coverage of personal, spiritual, medical, and legal wishes all in one document. We also have the 5 Wishes booklet available in our office in several languages. And again, as Heidi mentioned, links are at the end of this slide presentation and will be provided. The form on the right, Maryland Advance Directive Planning for Future Healthcare Decisions, is through the Attorney General's website and can be printed out online for free. So again, these are just a couple of examples to show you that advance directives can look very different from each other. Next slide. On the screen are several resources and links that were referenced during this section on advance directives. We have the link for the Maryland Attorney General Advance Directives Overview, a link for Maryland Advance Directive Planning for Future Healthcare Decisions, link for Maryland Healthcare Decisions Act Summary, and Aging with Dignity or 5 Wishes. Again, just a reminder, you will receive all of this information following the presentation. Next slide. Okay, so we've taken a deeper dive into advance directives, and now we'll be pivoting over to the Maryland Medical Order for Life-Sustaining Treatment, or the MOST form as we refer to it. This form goes by slightly different names depending on the state, such as Physician's Order for Life-Sustaining Treatment or Pennsylvania Order for Life-Sustaining Treatment. The MOST form is not an advance directive. Alternately, it can be complemented to an advance directive, but it is a medical order completed by a physician with the individual that outlines the individual's end-of-life preferences for medical care. The most is often completed when an individual is faced with a serious health condition or when they are near end of life, and is a way of providing specific guidance to healthcare professionals. Next slide. Sometimes if you ask the client, have you ever completed advance directive? They might respond something like, sure, yeah, the doctor did one when I was in the hospital last time. Chances are a most form was completed and not an advance directive. So let's differentiate a little bit between the two. So the most forms are signed by a medical provider, and most forms don't name a healthcare agent. Advance directives are signed by the individual, and advance directives can include naming a healthcare agent. The way the most form is understood, the main purpose of it is to indicate CPR code status and if someone would want to be resuscitated or not. Yes, they want CPR, or if their preference is a DNR order or do not resuscitate. The document also indicates other life-sustaining treatment options. So again, the document is completed and signed by a healthcare provider, usually a physician, a nurse practitioner, or physician's assistant, in conjunction with the individual or their decision maker. And the document should be completed when an individual discharges from a hospital to a nursing home health care, for dialysis, to an assisted living facility, to hospice, or transferred to another hospital. Next slide. This next slide is a copy of the most form. This is a 2-page document, usually front and back. The first section is who the medical provider reviewed the form with, and the bottom portion of the first page is specific to the CPR code status. The second, or the back page, has the other life-sustaining treatment measures. Very important thing to know about the most form. It's an important document that emergency crews, the ER staff, other healthcare professionals can rely on to know someone does not want to be resuscitated. All persons involved in the individual's life should be aware of their wishes to not be resuscitated and know where to locate the most form. Additionally, in Maryland, with the most form, there's one specific company, Medic Alerts, that can issue a bracelet to note resuscitation status by providing a copy of the completed most form to the company. Next slide. Again, we have some links for resources pertaining to the most form. We have the actual link for the Maryland most form, link for Maryland most overview and resources, link for Maryland most frequently asked questions, as well as additional information on the Medic Alert bracelets, as well as a link for Maryland Healthcare Decisions Act summary. Next slide. So we're now going to hand it over to Megan to take over for guardianship.
Hey, thank you, Tangen. So as Tangen mentioned, we'll go ahead and switch gears from advanced directives and the MOLST form over to guardianship. This is another one of those words that we saw a few slides back on the confusing language slide. So I'd like to start just by first defining guardianship itself. When we talk about a guardian, we are talking about someone who has been granted the legal authority to make decisions for another individual. And that's the key word here, is the legal authority. Minors have legal guardians, and so do members of vulnerable populations who are not able to take care of their own personal and financial needs. For individuals under 18, parents are the default guardians without having guardianship be appointed. Next slide, please. Okay, so there are two types of guardianship. A guardian of person is someone who makes decisions about things such as medical care and where the individual will live. A guardian of property, on the other hand, is someone who makes decisions about things such as finance and property. There can be a court-appointed guardian for one or for both, but any form of guardianship, again, must be appointed by the court. Next slide, please. So let's talk just a bit through the basic framework. of the guardian process in Maryland. I just want to give the caveat, though, that there can be many additional steps and turns along the way. We're just going to go ahead and cover the highlights in the process of establishing guardianship, which is initiated when an interested person or persons files a petition with the Maryland Circuit Court. There are multiple individuals and groups who meet the criteria to be considered an interested person or persons. This could be a family member or even a government agency who pays benefits to the individual. So there's quite a range of individuals who could serve in that role. Included within the petition must be 2 certificates of competency signed by healthcare professionals, licensed healthcare professionals, stating that the individual is in need of guardianship. These are also known sometimes as capacity certs, you may hear. Once the petition has been filed, notification of the filing is then sent to all interested persons. And this gives interested persons other than the petitioner the right to intervene if, for example, they do not believe a guardian should be appointed. In addition to sending notice of the filing, the court appoints an attorney for the individual if they're not all represented by a lawyer of their choosing. And then next, the hearing or trial is held to determine if a guardian is needed, and if so, who is the most appropriate guardian for the individual. If guardianship is established, the court then provides training and orientation requirements for guardians to ensure that they're really supported throughout that process. Those requirements don't apply to public guardians, and public guardians are guardians who serve through the local Department of Social Services or area agency on aging. Next slide, please. Okay, and what you see on your screen is an example of the court order appointing guardianship of an individual. In this case, a guardian of property has been court appointed. So this is something that'll also be included in the slide deck so that you can take a closer look. Next slide. Okay. We have several excellent resources here that further explain guardianship, and that, again, we'll share after the webinar. Next slide, please. Okay, now let's take a few minutes to cover an alternative to guardianship. This alternative is something that's known as surrogate decision-making, and it's one of several options that is less restrictive and can sometimes be used in place of guardianship. So surrogate decision-making is also a tool that can help an individual as they transition away from the status of having a guardian. A surrogate decision maker is someone who has the legal capacity to make healthcare decisions when the individual is not able to do so or when they lack capacity to do so. Surrogate decision makers are identified through legal documents such as power of attorney. We come right back to the confusion in language, as the term surrogate decision maker can also be synonymous with the term healthcare agent. And that's something that we talked about when covering the power of attorney information. However, surrogate decision-making also stands alone as a concept that's independent of the power of attorneys and other legal documents in Maryland. Next slide, please. Okay, so in Maryland, if no other legal document is in place and the individual has been deemed incapable of making decisions, Maryland actually outlines a specific order for who acts as the surrogate decision maker. I just want to consider this example. Let's say that an individual has been separated for 20 or more years, but never legally separated. They no longer have a relationship with their spouse, so the spouse would not necessarily be in tune with the individual's healthcare preferences. If the spouse hears that the client isn't doing well, they may come out of the woodwork and be identified as the surrogate decision maker. And this is an example of why it's important to at least name a healthcare agent while you are cognitively able to do so, so that you're not in a position, or that a loved one's not in a position where someone who you wouldn't want to be making decisions on your behalf is naturally put in that place. Another example to consider would be if surrogacy falls to adult children. And what if they're not in agreement with what decisions are made and how things should be handled? These situations can get quite messy, and sometimes ethics committee meetings must take place to sort it out. Next slide, please. Okay, and this list is not exhaustive, but these are a couple of good resources related to surrogate decision making. Next slide. Okay, this is one final topic that we're going to cover before we circle back and go through a summary of what we've discussed. And the final topic considers yet another alternative to guardianship, And that's supported decision-making. This is even less restrictive than surrogate decision-making. Supportive decision-making does not require a legal component. Next slide, please. Okay. Supported decision-making really plays a key role in promoting self-confidence, pride, and control over one's own care because it gives people the opportunity to make choices about their own lives with support from a team of people that they choose. Supported decision-making is also a tool that can be used to support individuals if they're able to transition from a higher level of support to increased independence. Next slide. And again, these resources specific to supported decision-making that you see on the screen will be shared after the webinar. Next slide. As we wind down, we wanted to just briefly share this summary chart, which will be included with the slides that you receive as well. The differentiation between some of the terms that we covered will hopefully be a helpful visual that you can reference moving forward. And you can see that along the left-hand side, we have the different types of documents or individuals holding positions. And then across the top, it shares who decides for each, who signs, and who has the capacity or ability to be able to change those documents as well. Next slide. Finally, as we wrap up with the presentation portion of today's Community Enrichment Series installment, I'd like to leave you with just a few examples of some really challenging real-life situations that highlight the importance of pre-planning, just to ensure that your wishes or those of someone you love are carried out. So there are scenarios that you can imagine where perhaps a widowed mother of 4 adult children has an unexpected medical emergency and tough decisions are needed about life-saving medical interventions. As we mentioned just a bit ago, with multiple adult children falling into that surrogate decision-making role without any sort of advanced preference put in place, it could get a little bit sticky for sure. We could also consider the situation of a minor who is non-communicative and about to turn 18 and become a legal adult. Like other 18-year-olds, what will the expectation be? Will they control their own finances? Will they make informed decisions about where to live and about medical care? Or what if your adult child becomes unconscious or stops breathing and they go to the hospital? Will the hospital or ER share confidential information with you? Who will make those critical decisions about their care? Let's say we have an 85-year-old family member whose chronic illness causes a decline in cognition. Who decides for that person about their medical care? Or the cancer patient who is terminally ill and becomes unable to make decisions about their care. Who has the authority to make decisions on that person's behalf? I know those are very tough situations to think about, but just situations that we want to bring up because they really lend proof to the idea that the planning in advance can be so beneficial in so many ways. Okay, next slide, please. And these are just a few additional resources that we wanted to share as well. And we are going to transition over to our next slide and any discussion portion, any questions that anyone might have or anything that anyone wants to share. And I believe we're going to go ahead and stop recording at this point as well.